today, my role is, and I will show you why we believe that mediation is important and what advantages, but also what limitations it may have. And before I want to start digging into these issues, I will briefly set the scene, because my understanding is that the vast majority of those listening here now in this webinar are familiar with mediations, are even mediators, have mediation at their office, at their law firm. But my understanding is that there also might be some who are not so familiar with it. So I will give a very brief introduction of, let's say, what mediation is, so that we set the scene and everybody is on the same page. Okay, then let's start. The mediation, what does it mean? To give a very clear definition. It is a structured process, however named or referred to, whereby two or more parties to a dispute attempt by themselves on a voluntary basis to reach an agreement on the settlement of their dispute with the assistance of a mediator. Now here, this is the core and most common definition of what mediation is. And this process may be initiated either by the parties, or it can even be suggested and sometimes ordered by a court or prescribed by the law of a member state. As you all know, we are all coming from different legal background, jurisdictional systems. This depends very much on the specific system we are working in. So, for example, in the European Union, in the vast majority of member states, mediation cannot be ordered. It can be suggested, but there is no obligation to do mediation. But there are other countries where it is actually an obligation. And it depends also on the context, if it is obligatory or not. And those who are mediators here amongst us, you know that there is always a huge discussion if it actually should be always obligatory or it should not. But this is not the talk today. This is then maybe for next time. Very important in mediation, we of course have to deal with the legal issues, but primarily, that's very important, we focus on the commercial interest and business solutions. And I think that this is a very, very important, let's say, difference between mediation and many other traditional proceedings and other alternative dispute resolution tools. Because here, the core issue are the parties and their business interest. And the idea is to constantly reconcile these interests and to find a solution. And you know that the mediator is always saying it is not about to divide the pie. It is actually about to enlarge the pie. So that actually we have not only one pie which we can distribute on the parties, but we may even create 3, 4, 5, 6 more together. I also have to say, and those mediators know it, it doesn't work always like this, but it can. And it depends very much on the mediator and its skills. The process is very flexible. We will see that in more detail later. Also important that all the parties and their legal representatives are attending the mediators, in particular parties, because as I said before, it is about the parties. So they need to be there, which is sometimes also a problem, because in a mediation, we have to make sure that we have the core people of a company, those who can take the decisions, must be at the table, because it is a process where positions and interests may change over the day. And that always requires the possibility that the person sitting at the table can actually take a decision and go in another direction. Very important characteristic of mediation as well is the confidentiality of the parties and the mediator. Don't forget, all proceedings at IPO offices, at courts, they're public domain. And especially nowadays, in the area of social media, I strongly believe that mediation is one of the most important tools to settle disputes in order to avoid that a certain dispute becomes public domain. I will come back to that later and give you some examples where I think it demonstrates very well the usefulness of mediation in that area. Okay, now I want to give a brief overview of the complex nature of IP conflicts. And the next 3-4 slides will sound very familiar to you. I will not spend a lot of time, but it's very important because it reminds us all of the complexity of IP, of intellectual property conflicts. So I will go through it. You will know everything, but it's important again to understand the background, and then I will come to why and explain why we think that mediation is so useful. And of course, also where the limitations are. So in IP, you know that we always or very often have the concurrent rights. So at the same time, parties are fighting over trademarks, patents, designs, or copyrights or other IP rights. We may be involved in different legal and jurisdictional issues at different levels in the EU, in one of the member states, in Asia, in America. I remember a case I mediated together with Gordon, we'll listen later, and that involved a dispute of 40 parallel cases which were pending at courts and IP offices throughout the world. And the parties at 2 o'clock in the morning, very tired, could actually settle that dispute once and for all. And I think we all agree in IP conflicts, you have the situation very often is that you are not only involved in one dispute between the same parties, but in many, many different as well. And I think it is of the interest of the parties to try to find a global settlement. So these are the parallel proceedings you see here on the screen. And then, of course, IP conflicts need close and intensive monitoring and coordination on each side of the parties. And that costs money. We talk here about direct costs and indirect costs, because the court procedure, you have to pay court fees, the lawyer's fees, all these fees are direct costs. But don't forget that there are also indirect costs. Each conflict, and the more complex it is, the more money you will spend in your company to run and coordinate and monitor this conflict. Because you need staff who coordinates that conflict, especially if it's pending in several jurisdictions. So here, again, I think it could be of interest to settle disputes more effectively. And then, of course, the stakes are high and risks are significant in IP conflicts. It's also very difficult to predict as a lawyer, and those being lawyers here today, it's very difficult to say what the outcome of your case will be in Asia, in Indonesia, in Singapore, or in the United States, or in China, or in Europe. But it's always the same trademark, always the same parties. So you might have even end up with divergent decisions, some saying there is likelihood of confusions, others say no, there's not, or only partially. This is not very satisfactory for the companies. So maybe again here, a negotiated settlement could be useful. And then, of course, the area of enforcement is always very, very tricky. So we have basically two areas where we find IP conflicts, either before IP offices or before courts. Again, in offices, I said it, you may have trademarks, patents, design, and utility model proceedings. In some countries, you even have copyrights, registration before the IPO. You have trademark opposition, you have cancellation, invalidation, also for patents. You have design invalidation, copyright issues. So all these you know perfectly. But they can actually be combined, meaning that the same parties can be involved in these proceedings at the same time, which creates a lot of complexity to an IP dispute. Also, you might have conflicts between different IP rights. I mentioned that before. Then the question always comes in counterclaims. If I am threatened in an infringement proceedings or in an opposition, I can request the proof of use of the earlier mark, or can even go for an independent revocation proceedings. So that adds complexity to the case. And very important, I mentioned it at the beginning, before IP offices, the focus is usually on legal matters, but there is no consideration of personal and business issues. And of course, again, the disputes appears in the public domain. Let's move now to court proceedings, the second area of IP disputes. We have, again, infringement actions, interim injunctions, enforcement issues. We have also disputes before courts regarding contractual disputes, license, franchise, transfers. Then we have what I mentioned before, the counterclaims, which again adds complexity to the dispute. We have the involvement of local lawyers, which not necessarily are your so-called house lawyers. It's not the lawyers you're working on a daily basis, but if you go to another country, you usually have to hire another lawyer, which is not, let's say, your business lawyer. So that may also be a disadvantage. And again, the court proceedings appear in the public domain. As you all know, we need to prove the facts by evidence. The lawyers and paralegals need to investigate and assemble the client's version of the story. We may need expert evidence and even witnesses. Then we have preemptive cancellation actions, so declaration of non-infringement, or an EUYPO, a cancellation action filed by the defendant to infringement claim, what I mentioned before. So each of the parties in a very serious case are threatening and challenging on all areas. And that's, I would say, is not the exception. It is rather a rule. Then you have a serious risk of forum shopping, at least at the European Union. So you can actually choose a court which is for your client's interest better, either be the court which decides very quickly, or it is a court where you know that they're very, very slow and need years to take a decision. That's another issue which adds complexity to IP disputes. And then, of course, we have, I mentioned before, the risk of uncertain outcomes or even divergent decisions. And, mentioned before as well, we focus on legal matters, no consideration of personal and business issues possible before the court. The court can only rule over the facts presented. I know in many jurisdictions you have oral hearings. And some jurisdictions, for example, in Germany, I'm German, I'm coming from the German background, in oral proceedings, the judge always tries to find a friendly settlement with the parties. But again, there is no much time for it. And there is definitely no time to really dig into the process and dig into the conflicts to see the global picture. That's not possible, but it's possible in mediation. Here, I show you an example of the EU TM and registered community design legal system in the European Union. Not go into detail, it's not important, but I want to show, and I think it shows very well the complexity of the legal system in the European Union, which is, by the way, very similar to all other countries in the world, because IP, for example, for trademarks, the Paris Convention behind. So we have very, very similar, if not identical rules. So the complexity is everywhere. And here only in the EU, you have three different pillars. You have the European system and you have two national systems. All this adds complexity. And depending on which side you are the defendant or the claimant, you need to go the one way or the other. And then you may even be involved in counterclaim proceedings. So again, I think this shows very nicely the complexity of IP. And in all this, we also have to bear in mind that at the EUYBO Boards of Appeal, for example, we have taken 30,000 decisions since 1998. Some 3,000 appeals are taken every year to the Boards of Appeal at the EUYBO. The next instance for us is the Court of Justice in Luxembourg. They decide over more than 3,500 appeals per year on intellectual property. And then we have hundreds of thousands of judgments and decisions by national courts and national IPOs. And if you multiply this now to the international level, the number is much, much higher. What do I want to say with this? I want to say that you have millions of decisions, and it's very difficult to be consistent and coherent. We all do and try our best and have very good mechanisms, especially at the IPO offices, to guarantee the users a coherent and consistent system. But it's not always so easy. And sometimes it's difficult, again, to predict the outcome. and to give a clear advice to the client. And therefore, we believe in specific complex cases it might be useful to engage into mediation. Time is a big issue. I mentioned it already. Some proceedings in our system can last, as you see here, until 23 years. But is this really satisfactory to the parties, to the owner of these IP rights? They need to wait 23 years until they know if their right will be registered or not. They can't do business with this trademark because there is no legal certainty. So time is an issue. And if you take it to mediation, it can be settled within a day or within a week or within a couple of months. Comparable to 23 years or 14, 15 years, that's not a lot. And you have legal certainty. Here you see the average length of infringement, of IP infringement cases at the different EU member states. And you see that in most of the countries mentioned, there is an increase in the length between 2013 and 2017. So again, it shows the complexity. It shows that the court proceedings may not be the most effective way of settling a dispute. Let's come now and also discuss a limitation, because so far I have rather said what are the advantages. But there are, of course, also some limitations which needs to be clearly identified. So, for example, I think we all agree that you can't offer mediation in ex parte proceedings before an intellectual property office. If a trademark is acceptable on the basis of absolute grounds, it's a question of public interest, which cannot be negotiated. So here we believe, and I hope that everybody agrees, mediation is excluded. Or can a patent be registered? All these questions, all these ex parte proceedings, they are not subject to mediation. But, and let me stress that, nevertheless, there are a lot of IP offices, especially in Asia and also in Europe and in the United States, where actually the offices offer support service to the applicants in order to make their IP rights registrable. I know this is not mediation, but what is behind is the same. They want to support the applicants and they want to help them to find the solution to their problem. So it has a lot of in common, but again, we can't engage in an official mediation process for these cases. I think we all agree as well that mediation is not suitable for counterfeiting and piracy cases, because this involves criminal law, and this, of course, cannot be negotiated. However, let me nevertheless stress that we have discussed a lot at the EUYPO whether we can mediate bad faith cases. And I have to say that at the beginning, I was very reluctant because bad faith cases are a bit similar to counterfeiting and piracy cases. But there are also very important differences. And if you see from the file that they actually involve business disputes behind, we believe that mediation is a very useful tool for bad faith cases. Some are excluded if you have clear indication that it's actually more regarding counterfeiting, but others are definitely suitable if you see that a bad faith dispute, actually the dispute behind is a business conflict between two parties. And there you can offer it. We have done it very successfully. So we always look carefully at our bad faith cases to see if there might be suitable for mediation or not. Very important is as well, both parties must be open for mediation and they must be ready for compromises. All mediators here knows we call this the give and take approach. If the parties are not ready to give and to take, or to take, everybody wants to take, but to give, that's the point. If they are not ready to give, it's very difficult to initiate a mediation. So what I personally do, I've been now mediating for, I think, 25 years. I always start with a phone call to the lawyers, but also to the parties. And I remind them from the outset, listen, you need to be ready to give. If you don't want to accept any compromise, don't start the mediation process. Then it's really the loss of time. And I also ask the parties, before starting the mediation, to already make a list of issues where they would be ready to make compromises and which are no-go areas. Ideally, I get this list before, but it's not always like this. But I would never send it to the other party. But it gives you a good indication how far you can go in the mediation. And again, it's absolutely essential. The parties need to be ready to give in this specific case. Otherwise, it will be very difficult to succeed with the mediation. I also believe that maybe mediation is not so suitable for legal, clear-cut and straightforward cases. There are some, I would say, I've been now chairperson of the board for a long time and working at the office, EUYPO, for 20 years. I also worked as a lawyer before. So I've seen a lot of conflicts, as all of you as well, I know. And I think there are very, very few cases where you would say that is a legal, clear-cut and straightforward cases. They hardly exist. And even if they exist, sometimes mediation might, again, contribute to not only divide the pie, but to enlarge it. So it might be, even for these cases, interesting to at least have a look if mediation could have an advantage. And then, if you engage in mediation, it is clear that you have additional fees for your lawyer who needs to, or who should be represented as well. In the mediation, you may need to travel, although now we're all used to use online tools. So we also now offering our mediation mostly online. And depending on the mediation service you're going to use, you might have extra fees. So if you have a mediation service of an office, it might be a fee. If you go to a court where they offer mediation, there might be a fee, or private mediators, of course. But there are other mediation services which are also free of charge. Okay, but let's go back to the advantages, which, in my opinion, these are the important issues. So again, mediation is cost and time effective, as we have seen before. And it's not only direct cost. I mentioned before the indirect costs, which I think are very important, especially if the conflict is complex and involves many other jurisdictional systems. A confidential process, mediation is a confidential process. I mentioned it as well. And now I want to give you the example, because you might even be a lawyer of a company which actually have a clear-cut case because there was a clear infringement of your client's IP right, but it was infringed by a rather small company or maybe an individual. And when infringing this person or this SME, you might trigger a counter attack against your company using social media. And I think that this is a very important factor which all lawyers must take into consideration, because before the area of social media, hardly anyone knew about the court proceedings, because nobody was digging into the paper files of a court to see which type of proceedings are currently pending there. However, nowadays, all these conflicts are public domain. For example, our proceedings you can see all files online. And that's probably in many other IP offices and courts where you have access, if not to the file, at least to the general facts of the case. So it becomes public domain, as I mentioned before. And depending on the situation of the conflict, it can fire back to your client's company. And I remember, and I know a very good example, which is from Denmark, a country here in the European Union. There was a big company, very successful company, and they sued an individual for trademark infringement. And this person used social media to counterattack this company, and it did it very successfully. This huge company was close to become bankrupt because of this social media attack. However, if you try first mediation, which is a confidential process, you might find a solution with the infringer, which is you can even sign confidential clauses, and then it doesn't become public domain. Also, Mediation is the process tailored to the needs of the parties and flexibility. Gordon will now go into more detail when it comes to the description of our process at the EUYBO Boards of Appeal. Again, we focus on legal issues, but not primarily. The main focus are the parties' business interest. Law is usually focused on the past, unless you draft contracts, that's for the future. But in conflicts, it usually focuses more on the past, and people tend to be entrenched in the past. The role of the mediator, which I will talk about tomorrow in more detail, is to get the parties out of the past, out of the legal issues, into the future and business solutions. And if possible, it's not always possible, sometimes to enlarge the pie. And as I said, all pending disputes between the state parties can be involved. And from our experience, agreements resulting from mediation are usually more likely to be complied with voluntarily, and they are more likely to preserve an amicable and sustainable relationship between the parties. Of course, sometimes you will have a client who clearly said, I want you to go after this infringer or to go after that company. Then mediation is not possible. But very often, your client might be interested in actually maintaining an existing relationship or to build a new one. To finish my talk, and then I'm very much looking forward to your questions, and I hope you have sent me a lot of questions. I want to give you a kind of evaluation sheet where you can check all your conflicts and which gives you, let's say, an indication if mediation could be suitable and useful for your conflict or your client's conflict or not. So, as I said before, if I see from the file pending at the boards or the file you have in your law firm, or which is before the IPO, that this file shows that there are between the same parties many identical or similar proceedings in other countries, national, EU, worldwide. This might be a strong indication of giving mediation a try. Very often, this is combined with the conflicts over other IP rights. I might have a conflict in our mediation at the EUIPO Boards of Appeal. The starting point is, of course, always a conflict about trademarks and designs. But when digging into the file, we very often see that the same parties are fighting over the same trademarks in other countries. And very often at the same time, there are issues of copyright and domain name. Because you all know that usually you file a trademark, you register a trademark, and at the same time, you also register a domain name. So very often trademark cases are linked to domain name cases and also copyright and design cases. And we even had a case that the parties fought about a patent. So we asked, or we offered the parties to include all the parallel disputes into the mediation. Another strong indicator whether to consider mediation or not is to check the relationships of the parties. Do the parties actually have long-standing relations, be it the relationship between a licensee and licensor, agent, representative and trademark owner, the manager and the company, or maybe even family relations? If this is the case, it might be useful checking with the client, with the parties, if they want to give mediation a try. Because, as I said at the beginning, in court proceedings, in arbitration, you will not be able to include these personal and business issues into the procedure. Another indicator, and that's very important, is the party has already negotiated, but without success. I have to say from the very beginning that we cooperate with all the IP lawyers on a very, very good basis. And we are fully aware that more than 60% of, for example, the oppositions filed at the EUIPO are settled by the lawyers themselves with the clients. So they don't need any mediation or other supporting mechanism. It's the lawyer, thanks to the lawyer, that the dispute is settled. However, there are still thousands of cases where the lawyers have tried to settle, but they couldn't. And this doesn't mean that the lawyers didn't do a good job. To the contrary, they do all an excellent job. But there is a fundamental difference between negotiation and mediation. In negotiation, as a lawyer, I have to defend the interest of my client, and I'm bound by that by law. If I do not defend the interest of my client, the client can even sue me. And I've also usually some financial interest to maintain my client. What I want to say with this is that usually the negotiations of the lawyers are excellent and very hard, but nevertheless, it is usually not so easy to challenge your own client on a specific position he or she has taken. Whereas a neutral facilitator, as the mediator, he or she can challenge your client in a very different way and can actually see if your client is ready to move and make a compromise. And also, if the parties have already negotiated, but they couldn't, let's say, they couldn't settle the case amicably, this is a strong indication that there is room for maneuver. And the case is usually very well prepared already by the lawyers. Sometimes we even have agreements they can send us, which are then the basis for the mediation. So the case is mature, but they need a last push from someone who is neutral, impartial to the parties and the clients. Another one, I mentioned it already, each party in all the proceedings, you will always have strong and weak legal points, especially if you're involved in many jurisdictions. You can never predict a case where you have even 3 or 4 different court instances. It's very, very difficult to predict the outcome, even in one country. But if you're involved in disputes in 40 countries, I would dare to say that's impossible. So here again, mediation might be a helpful tool mechanism to effectively solve the dispute. And that's the last indicator, and I will finish with that. If parties are doing business in different areas, that's of course a strong indication that there is room for settlement. These cases are usually settled by the lawyers, but again, sometimes for whatever reason, it isn't. And if I see in a file that a company has registered or tries to register a trademark for 45 classes, for all the 45 class of the NIS classification, I think it's pretty obvious that they will not use this trademark for all these goods and services. So maybe by looking into the internet and finding out where the party actually does business and the other one, you may help them to restrict the list of goods and services in order to overcome the dispute. And this, of course, can be done by the support, with the support of a mediation to these proceedings. Okay, thank you very much. And now I'm looking forward to answer the questions.
Thank you, Sven. Now we go on to the questions that have been posed by the participants. So we have the first question on who can be the IP mediator and in what stage, I guess, of the dispute is the mediation process ideally done. I know that you have another presentation tomorrow on the role of the mediator, and perhaps this is connected with who would be an ideal candidate for being a mediator. So, but maybe we can provide a preliminary answer to who can be ideally the IP mediator.
I guess you mean with who can be the mediator, if it should be someone, let's say, who knows about IP, who's an expert. And there is, of course, always a lot of discussion. again, as Jennifer said, the role we discuss tomorrow in detail, but to give you an answer, my personal opinion is that in particular in IP, I think it's important that you are, or the mediator is an expert of IP, because you have a lot of legal areas which you need to control, because don't forget, lawyers are clever and parties are clever, and they will use the system, and rightly do so, and find ways to get, let's say, to find doors to go out of the conflict. I remember a system which is maybe not so familiar for you. It's in our EU system, you know that we have a European trademarks and we have national trademarks. And actually, if you have a European trademark which is refused, let's say because it's descriptive, you can convert that European Union trademark into a national trademark. Okay, so you don't have then a European protection, but you only have a protection in one country, for example. And for that, you have a deadline of 3 months to file this request to convert. In one of the mediation, one of the parties played and always said, look, I don't need to settle, because if you destroy my EU GM, I convert back into national trademarks. I knew that the client, the lawyer, had missed the deadline to file that conversion request. And that was crucial. So I went into a caucus and a private chat with the lawyer and said, look, you are bluffing, because I know that you can't convert because you have missed the deadline. And I said it only to him. That's very important. You can't say that in the main session with all the other parties and even the client present. I only said it to him. He immediately understood. And I can assure you, after 30 minutes, we had a deal. But of course, if you are a mediator who's not an expert in IP, he or she wouldn't have seen that he was bluffing, because that's very important. So my opinion is, I think the IP mediator or the mediator needs to be an IP expert. It mustn't necessarily be a lawyer. If we have colleagues at the EUYPO who've been working in IP for 20 years, they're not lawyers, and they know everything more than I and Gordon do. So they can, of course, do it. You mustn't be a necessary lawyer, but you must know about it. I hope this answered your question.
Maybe on the timing or the stage of the dispute where mediation is most ideal? I think that was the follow-up question.
At which stage it is most suitable? I would say as early as possible. We are now at the EUIPO, and Gordon will give you some more information later. We are now also considering to extend our service to IP dispute prevention. So I would suggest the earlier you engage into mediation, the better. You could even think of a system where you offer a mediation even before a dispute arises, because you of course, if you create a trademark, a patent or whatever, you know the market, and you might see, there might be a conflict in the future with a specific company. So you can address that company and say, look, I have this invention, I have this trademark, I want to do this business, I see there might be conflict. Could we try to prevent that conflict by engaging into mediation? So yes, the earlier the possible, but on the same side, mediation could also be possible at the very late stage. I remember I did a mediation where the proceedings at the last instance, and we have 4 court instances, was over. So there was no further way. So it was clear one party has lost the case and one party won. But nevertheless, I could convince them to mediate. And the reason for that is that the other one would have filed the same trademark again. And then it's ending up in a never-ending story. So the earlier you do it, the better. But you can do it also on the very, very late stage. And it can then also, again, prevent future conflicts. And you can be able to create common business areas.
Just to address some of the other questions, there are questions about the mediation process and statistics in the EU. We will have this answered later on by Gordon in the subsequent webinar on the EUIPO Boards of Appeal and the EU regulatory framework on mediation. But I would also like to ask this question as a last question before we head on to the next webinar. The question was, do you think enforcement of the IP mediation conclusion after agreeing is a limitation or an advantage of the mediation. So sometimes problems arise when you already have an agreement, but there is difficulty in actually enforcing the agreement.
Yes, I mean, this is a very good example, another example which I will add to my slide for the next presentation I will give in the future. That's a very good example. So even if either after enforcement action, the lawyers have negotiated, but then a new conflict pops up. So yes, very useful here, mediation. And I would recommend to actually include clauses, mediation clauses into the contracts, into the agreements. We are currently developing these new contracts, which Gordon will also explain a bit more detail. So we are actually want to offer the users to add these clauses in contracts so that you actually, at a later stage, can engage into mediation and oblige both parties before they initiate court proceedings.
Thank you very much for joining the first webinar.
Okay, thank you very much to all of you and see you tomorrow.